Hi, my name is Kyle Courtney, and this is day 2 of Building LLTDM. Right now, I'm very happy to cover copyright basics with you. Copyright law is part of the legal system that covers both creation and use, and is filled with exceptions and exemptions that strike a balance between the exclusive rights granted to creators and the rights of many users, including text and data mining researchers. For our discussion, I will lay the groundwork for understanding both the rights and the exceptions with an emphasis on fair use, which in the TDM context is one of the most important rights that provides a legal justification for using the material that drives a TDM project, the copyrighted works themselves. So let's take a brief look at some copyright basics. In 1710, the English Parliament passed the Statute of Anne. This new law gave authors for the first time in history an economic incentive to create new works. Authors had control of their own works and the copies made via a limited economic monopoly, not unlike our modern understanding of copyright. This captured the first balance between authors' rights and the public benefit of copyright when works drop into the public domain. This is a temporary economic right that drove enough incentives for authors to continue to create new works. And of course, when the rights expired after 14 years, the work would drop into the public domain and anyone could use the work thereafter without permission. This encapsulated the cycle of copyright: creation, control, expiration, with the hope that further works could be created using what dropped into the public domain later. And in fact, this act started with the language, an act for the encouragement of learning. So this concept moved into the US system in our Constitution. And certainly the members of the United States Constitutional Convention were aware of the ideas and control and censorship as the US emerged from English rule. In 1790, pursuant to their constitutional authority in Article 1, Clause 8, they said to promote the progress of science and the useful arts by securing for limited times and authors and inventors the exclusive rights to their respective writings and discoveries. The Congress passed, with this authority, the first copyright law. It was signed by George Washington, and it was also titled an Act for the Encouragement of Learning, and featured the same balance that the English had revolutionized with the Statute of Anne, an incentive of a limited economic monopoly granted to authors over their works, followed by expiration of those rights, the works dropping into the public domain. The current copyright law that is on the books is based on that initial law, but now it is in the US Code as the Copyright Act of 1976, and it similarly protects original works of authorship that are fixed in any tangible medium of expression. So what is an original work of authorship? An original work must embody some minimum amount of creativity. Courts have held that almost any spark beyond the trivial will constitute sufficient originality. On the other hand, the Supreme Court ruled in 1991 that a garden variety alphabetical white pages telephone book lacked the minimum creativity necessary for copyright protection. This is called the Feist case. The US Supreme Court held that the copying of a white pages book was not infringement because there was no existing copyright in that white pages. However, although facts themselves are not copyrightable, the way the items are categorized and arranged may be original enough to satisfy originality. Ultimately, this creative threshold is also touched upon in another part of Copyright Act. Section 102B states that a copyright's threshold for originality does not extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery. From this, we gather an important point for authors and creators, that facts are not copyrightable. So what is copyright really? Is it a bundle of rights? Is it a limited economic monopoly for authors? Or in the constitutional narrative, is it a system to promote the progress of science and the useful arts? Well, actually, for it to work, it has to be all three. The cycle of creation, dissemination, and expiration of rights into the public domain is a critical component of copyright law. Without this balance, the system loses its value or prevents the public from receiving the benefit of the bargain, granting limited economic monopolies to incentivize creation and then effectively giving that material to the public for unimpeded use. This then inspires more work to be harnessed and used. So when a work is created and fixed, these creators automatically get this exclusive bundle of rights. These are the right to reproduce the work, to prepare derivative works, to distribute copies, to perform the copyrighted work publicly, and to display the copyrighted work publicly. In 1790, when George Washington signed our copyright's first law into existence, the protection was limited to books, maps, and charts. However, under the Copyright Act of 1976, the subject matter has extended into these 8 extensive categories: literary works, musical works, including any accompanying words, dramatic works, pantomimes and choreographic works, pictorial, graphic, and sculptural works, motion pictures, other audiovisual works, sound recordings, and architecture, which was added as late as 1993. So there's a great deal of material that has the potential to be protected by copyright. Occasionally, we also learn about copyright by viewing what's not copyrightable. For example, there are other parts of the intellectual property law, which copyright is a part of, but is not under the umbrella of copyright. Slogans and logos, which are part of the trademark law, are all about what the mind of the consumer thinks when they see a logo. Patent covers process, methods, and systems that are separate from copyright. Secret formulas and recipes that are not disclosed to the public are generally considered trade secrets. They derive economic value by not being disclosed to the public. And then, of course, there's raw data. As we know, you can't copyright a fact from our White Pages telephone book case. Applying that holding here, raw data then, viewed as a set of facts, is uncopyrightable. So in order to know copyright, you need to know these 6 things: that creators get copyright in the works that are original, creative, and fixed in a tangible medium of expression; that no registration is required to get copyright; the work is automatically granted protection under copyright if it's creative and fixed; that the grant of rights to the author is represented by the exclusive bundle of rights in Section 106; and that there's a wide range of protected works, and they have a long term of protection. Yet despite all these rights, there are numerous exceptions and limitations. The focus of our inquiry for text and data mining will be Section 107, which is fair use. But let us for a moment take one last look at the duration of copyright. When copyright was first passed in Congress in 1790, they set a term of protection for 14 years, with a potential 14 years renewal if the creator chose to renew that. In 1909, they doubled that timeline and moved to a 28-year term of protection with a potential 28-year renewal. In 1976, in accordance with harmonizing copyright law internationally and as part of the Copyright Act of 1976, the term was set to a life of the author plus 50 years. And in 1998, that term was expanded 20 additional years. And so the copyright today is measured by the life of the author plus 70 years. But what happens after expiration? Our next segment will cover that which is in the public domain.